Good morning, everybody, and this is the introductory and the first lecture on the contract and how the contract law evolved. So let's begin that how this 1872 Act in the year 2025 is still having relevance, and all our contracts and agreements are based on this. Now you have to note and understand that our entire legal system is based on common law, and this common law started developing during the medieval time, or you can call it 18th and 19th century. The concept of contract comes from the word called assumpsit. Now, what is this assumpsit? Assumpsit is simply a promise. That is how it started. Or it was a way to seek compensation, which was being formed, rather came into prominence sometime in early 16th century. And it was considered as, the breach of informal agreements, because that time there was no proper agreements which were being recorded as far as the common law is concerned. So those agreements, first of all, started circumferencing the crime and the tenure part of the contract. Now, this doesn't mean that our society, Indian society, was not having laws prior to 1872 or when 1872 was there. Now, you would know that Hindus' laws are part of, or they're a compilation of smritis. They have been heard by somebody, they wrote it, then it was told to somebody. So smriti se hamare law develop hue. Now, those smritis law later on came into literature, and that is how our laws started codifying. And where they are codified in Dharma Shastra, where we find the rule of governance, of the contract, and other so on. Now, there is a particular Shastra called Shastra Kaliya, which can be called as a secular treatise of that time, which talks about purely on policies and governance. So 1872 Act is a different act which talks about two parties, about the contract, two private parties, but we were having some sort of, secular laws and treatises were being developed way back when Shastra was there, which talks about policies and governance. Still, we were not having specific laws relating to contracts. But it is very important that one must know that there is another Shastra, which is called Narad Shastra or Narad Smriti. Now, here, they gave the entire power to king. And they said that if somebody has to decide on anything, it is the king who will decide. So king came into prominence. Along with king, two other people came into prominence in Narad Shastra, which was Vedic teacher and head of the household. So these three people became some kind of, we can say in modern day terms, that they had the judicial power to decide on something if it was to be decided. So that we must understand. And king's verdict was enforceable, that he can enforce it. When I say enforceable means it can be enforced by the force of power, force of law, that king has said like that. Now, you also know in Indian society, we had the concept called rin. Now, how this rin is started? Rin is kind of a loan. It can be any loan. Pit rin and mat rin also considered as rin. Now, this concept of rin started developing way back during the period of Rig Veda. Now, that time, obviously, money was not getting exchanged. There was no written contracts. So it was a spiritual debt, which was on son. That as a son, I was having Pitrin, Matrin, Gururin, and so on. And this concept later got developed. If you are not able to अपना आप ऋण नहीं चुका सकते हैं, then you become a defaulter. कैसे आया वो? कि जैसे पिता की प्रॉपर्टी के ऊपर कोई अगर ऋण था, तो आपका चुकाना, इनहेरिटर का चुकाना, ये दायित्व था ये ऋग्वेद हमको बताता है. Now there are other scriptures like Yagnavalkya Smriti, which talks about certain laws. If you talk the other side, when Mughals came into India, they also came, of course, with certain laws, and those are called Islamic laws. तो ऐसा नहीं है कि 1872 के पहले हम बिना लॉज के थे, लॉज थे हमारे पास. अब इस्लामिक लॉ जब आते हैं तो देवर बेस्ड ऑन कुरान एंड हदीस, मोस्टली डेवलप्ड इनटू परफॉर्मेंस ऑफ कॉन्ट्रैक्ट. यहां से कॉन्ट्रैक्ट की बीज बनना शुरू हो गई थी, क्योंकि इन्होंने कॉन्सेप्ट ऑफ जुर्माना स्टार्ट किया. मतलब जुर्माना तो उसी के ऊपर लगेगा जो ब्रीच करेगा. तो मुगल के आते आते ब्रीच का कॉन्सेप्ट शुरू हुआ, ब्रीच को रिकॉर्डिंग का कॉन्सेप्ट शुरू हुआ, और जुर्माना शब्द आना शुरू हो गया. अब क्या होता है कि इंग्लिश आए, तो इन्होंने कुछ समय तक हिंदू और मुस्लिम लॉ को दोनों को मिक्स करके रखा, and they were not really comfortable on either of these laws, although they continued for these laws for some time, and then they decided that, look, we have to come out with our laws, which were called as a common law, what we know. Now, even Supreme Court of that time used to consider Muslim law and Hindu law for their judgment is concerned. Now, what we see today, that concept also did not start all of its own in 1872, but way back in 1180. When Levin, who is the English author and writer, tells us that it is not the custom of the court that Lord King should protect any private agreement. अब आप समझिए, उस समय बात हो रही थी कि साहब जो किंग की पॉलिसी है उसको तो किंग देखेगा, बट contract between the two parties will not be seen or adjudicated by the king. That was said in 1180. तो अब आप समझिए, when the things go into negative, it is the time when the positivity is also taken place right there, because then the development takes place. Then the laws come into picture. Law do not come into picture just in a while. It requires a lot of time, lot of discussion, society's acceptance, and then the laws get developed. So it was understood that private, as far as the private disputes are concerned, enforcement of private laws are concerned, there king will not interfere. Now go back to Rigved. Rigved said that no, if rin is there, then the inheritor has to honor that rin. So हमारा law technically देखा जाए, Rigvedic time का law was much more advanced than what was developed by English in 1872 and prior to 1180. Now, earliest contract which developed, how really this contract came into being. Of course, when commerce started, dispute started, so compensation concept started, and therefore the codification was required. Then in practice, the first kind of contract law started when the concept of bond came into picture. Now, bond was very much prevalent in the society of England that time, because they used to generate fund out of bond, because they had to go outside, venture outside, and therefore bond was very much prevalent. If you see the Contract Act of today, which we enforce in our country, you will find the chapters after chapters in bond. And nowadays, the concept of bond is not that prevalent, what was prevalent during their time. Now, how would I say that when contract violation, the concept started? Please note that, the thought started somewhere in 1180 of negation, then acceptance, and by 1370, the concept of violation of contract started, when it was recognized that this type of law has to be there to regulate commerce. So earlier the law was considered as a tort fault or default, and as a private wrong, not considered in particular that they should be having particular laws. But yes, germination of law started as tort law or private wrong. So it started having something like, you can say that, legal protection. So private violations of certain promise started having legal protection somewhere in 1370. Then much later, somewhere around 1588, the doctrine of consideration came into picture. Now you know the three concepts of contract: offer, acceptance, and consideration. Consideration is paisa. That paisa has to be exchanged in order to make a valid contract. And when it got developed in 1588. Now, when the court started coming into picture somewhere in 1500, and there was good reason and sufficient reason, they would say, to create that promise. If you say that I want to go with you for a movie or I'll give you X money, they said no, it has to be sufficient reason for a contract. And then consideration has to be paid. And there's a very good case, very old case, which is Strong versus Whitefall in 1588, which developed the concept of consideration, valuable consideration, and it is the vistas of learning which reasons for the good and sufficient way of consideration, number one, and creation of promise. That is what we need to understand, that these concepts way back, somewhere in 1500 started developing what was later codified. Now, by this time, you know that concept was already getting established. Secondly, the course also developed the analysis of the relationship between the parties. Because you cannot make any party to pay penalty unless you establish a commercial relationship or any relationship whereby certain obligations do arise. And therefore, it is very important that this kind of consideration has to be understood. The Hunt versus Wheat in 1568, for example, there for the first time it was understood that promise and consideration are very important in order to get into the relationship of the parties who is promising, what he is promising, and to whom they are promising, and if promise fails, what would be the consequence. So that was in 1568, first time in Hunt versus Wheat. This is again an English case. A promise, they say, that might be motivated in the past or present, that doesn't matter, but promise has to be there, substantial promise has to be there along with substantial consideration. Now, it is very interesting that when we approach somewhere now around 17th and 18th century, slowly, these cardinal principles of contract came into picture, which is like valuable consideration or the considerable consideration, promise, and the breach of promise. अभी तक इसमें ऑफर और एक्सेप्टेंस का कॉन्सेप्ट नहीं आया, वो बाद में आता है. Now it is quite fascinating to understand that by 19th century the contract law being modified in the principal manner, when we see these kind of commercial activity came into picture, and as we see, but we should not forget the contribution of Adam Smith. Adam Smith contributed very highly and valuably in social contract, cooperation, contract law, in particular the freedom of contract. That's what he talks. He talks about, he's the proponent of laissez-faire economy. So therefore he talks that there should be absolute freedom when the two parties contract. And he wrote a lot on the contract and the freedom of contract, freedom of doing business, and that, as I said, that laissez-faire economy is a concept he started. But if you go back a little, somewhere in 1790, then John Powell said a very interesting quote, that it is important to have general rules and principles of natural justice and civil equity. So understand, almost 100 years back, the concept started germinating that we have to require law. Our society cannot be lawless. And therefore, even for the private wrong, earlier the concept was that king will not see the private wrong. But now by 1790, it was being considered that even for the private wrong, king has to interfere, the courts have to interfere. Now, thereafter, the many writers came into picture. For example, 1926, Edison came, 1847, Pollock came. Then 1875 again, Anson came with a new literature of civil law and jurisdictions. And we will not also forget concept of French people who contributed quite a lot as far as development of contract is concerned. Now, very interestingly, there was a case called Numerical Registering Company versus Samson, not Samsung, Samson, in somewhere in 1875, and they said that it is very important what was said earlier. He repeated in somewhere in 1875 on record that it is important that liberty of contract has to be there, because unless the parties are not free, they cannot write a good contract. You cannot say that you should be doing this or that. Parties should have absolute liberty as far as writing of their contract is concerned. And therefore, earlier thought was that private wrong should not be considered. So that concept got totally changed by the time when we crossed 1800. Now let us understand how this 1872 came into picture. Now 1872 comes from the Third Law Commission, or I would say that the lot of provisions of 1872 Act were copied or borrowed from New York Code of 1862. Now that was recommended by Third Law Commission of India during that time, and you would know that Lord Macaulay was one of the major. He had one of the major roles in contributing and developing this law of 1872. Now, I will not going as far as those details are concerned, but I'll certainly talk about, what was the position prior to 1950 and why I'm getting into 1950, because by that time in 1950, we got independence for 1947. Our own constitution was promulgated in 1950, adopted in 1950. And therefore, for me, as a student of law, it is very important that earlier legislations, whatever legislations were existing that time, 1950 becomes a landmark year for me to understand the law and the development law, the adoption of law, that how should we treat those English laws in free India. And therefore, 1950 is very important for me. And I would now point that how this law got modified as far as 1872 Act is concerned. So you know that when Constitution came into picture, we gave ourselves to the Constitution, the first line of Constitution, the preamble. We, the people of India, adopted this Constitution. And in this Constitution, by virtue of Article 372, any provision, 372 says, any provision, if inconsistent with the fundamental right, would be considered as void. Therefore, a lot of modification took place in all the legislations, not only in 1872 Act, but all the legislation. Because now, for us, for Indians, to which we gave ourselves to the Constitution, this, our mother of all laws, our Constitution became the guiding light, the guiding force for every law, that you cannot and you should not touch our fundamental right of citizens. So entire 1872 Act to large extent was rewritten to protect fundamental right of people. Now, state got power under 7th schedule to legislate, and therefore state also came out with certain modification, as you would see in the footnote of the Act, of the Bear Act, many a times. Now, we'll take the concepts and their development, then we'll talk about the essentials of the contract, but just wanted to make you aware that how the law of contract evolved, how it came into picture, and why in today's time we are still stuck with 1872 Act and how relevant it is. So we will talk about those developments sometime when we talk about the history of law, but for our purposes, we'll move ahead and leave this chapter for the time being here. And now we'll talk about the concepts of law, concept of contract. We'll talk about the offer and proposal. We'll talk about acceptance, intention to create legal obligation. We'll also talk about consideration, capacity to contract, free concept, and freedom concept and the lawful object, that what should be void, what should be not void, what should be legal, and many aspects of the Contract Act. Now, Clause 1 of the Act talks about commencement and jurisdiction. We'll talk about each and every clause and their cross references in the clause and how they are applied in the real principles when you write a contract, and how those contract, when you write, how they are interpreted in the judicial system and the case laws. So we'll talk about all those things in the subsequent lectures when we meet again. Thank you.